Now, Jenna, medically speaking, for your height, your weight puts you in what we call the disgusting range. Fortunately, there are solutions. For example, crystal meth has been shown to be very effective. How important is tooth retention to you?
It's pretty important.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise Crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
Oh boy. Welcome everybody. Another version of the LPR. We've already got people in the chat. Everyone's warming up because they say, and it looks like good. It looks good here. So I'm gonna stop streaming this one. Hello everybody. This is Tyler Yonke. Let's turn on some lights. Yo, so we've got some people here in the chat. We'll throw them up here. Jordan says, Baldaman and the Baldo Guard are in full retreat. Yes, they are. So we're going to go through a little bit. I had other stuff planned for tonight, and then he's still got our Colt 45 intro going. And then the Nick stuff came out, and by the way, you have Sean, potentially criminal, Nate the lawyer, who else was it? Kurt was doing something, legal mindset. They all threw out then this other legal. Everyone's doing their stuff and they're doing it right away because they're getting right on top of it. But I'm streaming on Friday, right? Because I'm like, hey, this is the day I do it. And this is, I'm sorry I'm late on all this, but we're going to do, I had some other, like I said, I had some other stuff ready to go. We're still going to talk about it because I think it all kind of mixes in here. And you saw the opening clip there about, meth being the form of, preferred form for celebrities for losing weight. And it makes you wonder what Nick really had in mind and if that was something he was going to be doing. Yeah, Baldo Gate for sure, JC. By the way, JC, I just thought, I was reading here in the Telegram. If you join Telegram for Tower Gang, don't do it. But JC, they were talking about Bob Murphy and yes, I know this guy. I defend people in New York City family court. Yes, I think we've communicated on Twitter a few times here. I'm trying to remember your name, Jonathan, perhaps. But anyway, I was just going to go back here of some stuff about Jeremy Kaufman and Bob Murphy did a breakdown of it, and I was gonna get into that, but I didn't think I thought it was a very clickbaity for Bob Murphy. He took umbrage with Jeremy Kaufman and his video, and I didn't think it was. I thought some points he made, kind of like what I made about it, which is I maybe wouldn't have said some of those things, but I think there were some good things that came out for what Kaufman, for what he did, and Bob Murphy. I mean, I don't know. It was somewhat good. Some of it wasn't. I don't know. Few understand how few rights you have. Exactly. And I'm going to play part of the rights thing I'm talking about here. And so with Nick, look, as a libertarian, that's my philosophy, right? But I live in the real world, and that's very important because as an attorney, and he says here, and all that info gets carried into criminal court. Yes, it does. What you have to understand is that the real world is out there. Okay. You may want to be Randy Weaver up there in the middle of nowhere in Idaho and just be out there, but the government could come back after you. It depends on what your situation is, right? What's going on. Nick has put himself out in this situation where he has criticized the local government a lot. He's hoity-toity online, big following, but then he did some things that weren't necessarily in the best interest of his family, okay? And all of that comes to fruition, and it puts a target on your back. Now, I'm not saying we need people out there making stances, but is this the guy that needs to be making the stance for you? Maybe you're not. Maybe you're into cruelty. You're not into the cruelty, but you don't like police force, right? You don't like the aggressive force that the police have done. And so you're somewhat siding there with Colin Kaepernick. But is he the guy that wears a Fidel Castro shirt to protest one of the most authoritarian police forces you've ever had in the Castro government? You know, is that the guy that you think needs to be taken on your case? So is Nick the guy that needs to be taken on your case at this moment? I would say probably not. Okay, with that in mind, here's a comment Nick had done in our chat a few weeks ago. He came in here and he watched it and he said, "You're missing the point." Now we're going to break down some of this, his denial of the Frank's motion. Sorry to spoil it here, the Frank's motion that he had done and motion to quash and whatever. But this was, and he had said, because there was a CPS letter, right? And we've talked about this, and this confused me when I first saw it. It was so out there. I'm like, maybe I'm missing something. But here's what he said. He said, no, you're missing it because you haven't seen the letter. Now, what he was saying I was missing is that we were talking about the warrant and the fact that the CPS had done an investigation. They had closed it. They sent a letter. And then the day that they closed it, that's when the police officer Pomplin took it up. Okay. So then he went further, because there was a stream that happened. So Nick says, you're missing it because you haven't seen the letter. The letter says the CPS report would not amount to criminal activity, even if true. Okay. So I don't know what was being accused at the time, because he said Pomplin asked to investigate legal activity. Well, no, what you saw in the warrant, he actually said there was illegal activity, which was, so what I would want to know is, let me see the letter, Nick. Are you saying that the accusations from the first CPS investigation were that you were using cocaine around the children, and the CPS social worker determined that this was legal activity? Anybody out there? Anybody out there? No. I suspect that the original report that came to CPS, and by the way, did you tell them that you were using coke, that you were getting drunk on stream, jerking around there, you know, all those things we saw? I doubt you did that, okay? I bet the initial investigation was perhaps maybe about the polyamorous relationships you were in, and that the kids were in disrepair and that kind of stuff, okay? If that's the case, that's probably not illegal activity, right? So I don't believe this tweet that he put up here, or this DM that he put up here regarding that. So yeah, yeah, so there's supposed to be one comment. Okay, well, figure out how to work that thing. We got more people in the chat. I'm saying hi as we come in here. Hi, John Demolition. And then we're going to kind of focus. So I'm going to not taking a look at it as much as I read some of this stuff. So get your comments in here. Getting drunk, passing out at 4 a.m., then driving kids at 9. Yeah, once again, those. What do you think? This doesn't make any sense. Even if true, I mean, this just doesn't. Let's go back to the tweet here, or the DM. Even if true, the accusations, really, you now I will say this, with CPS, they're not always investigating illegal activity, right? But they're talking about like emotional abuse. Not everything's criminal dealing with CPS. As an example, so my friend Andy, I talked to him today, and he's like, you know, kind of give me update on, and so I'm going to give a layout here of the cases that we have, the criminal side, the family law side. And he's like, look, if he gets convicted, as an example, Nick Rekieta, that is, what's going to happen with the CPS? And I'm like, look, the CPS thing is a little different than normal. Let's say it's 2 families involved, right? Or a divorced family, okay? Or they're not married, but they're fighting over custody. Someone gets called CPS, and it's a substantiation of abuse on one party. The other one is going to use that against them, right? Or maybe CPS actually puts what's called the safety action plan, and they make you sign it, the two parties, and they basically are saying, here's what you need to do to keep the kids safe. If you don't do it, we could come in and do something about it. If both parents are shitty, they may put them up for, like you saw here with the Nick's case, put them up for with other people for a while. Maybe it's up for foster care. If it's other one, they may recommend the parties, the children are with one parent over the other. That's not what you have. You don't have an adversarial situation with Nick and his wife yet, right? April's in the mix. That seems to me that should be that should be illegal. I'm kidding. So you don't have an adversarial situation with the two of them. So when CPS eventually washes itself out, and hang on, sorry, and Nick, by the way, I don't watch his stuff where he talks about his rehab and all that. I don't really give a shit. Okay. I'll watch some clips of his stuff, and I know he's coming out now saying some things about it. Whatever, dude. But with this in mind, okay, that at some point CPS is going to dissipate. They're like testing him. They're making him go to rehab. They do the alcohol assessment or drug assessment test, and they come up with some plans. And then at some point they're just like, okay, we'll have a follow-up. And at some point they're just going to close the case out and be done until another report comes in. Okay. So it's just going to wash. Now, if he gets convicted and they're not really going to be involved, CPS isn't going to have much or any say because the mom's there. Once again, this isn't adversarial unless they've dictated that or determined that one of the parents is more dangerous than the other, and it shouldn't be. It doesn't sound like that's what it is. So CPS is not going to care necessarily that Nick gets convicted or his wife. They could have the kids stay, in guardianship with the grandparents. Once again, CPS's involvement is going to dissipate. Okay. And it probably already is. Okay. It seems like he's getting tested. He's not, wanking off online anymore that we know of. But that's kind of where we're looking at here. Right. Okay, Jonathan says here, but they closed the investigation and it was founded and filed in court. Yeah, well, they can have a new investigation, okay? Because what happened? CPS closed the case. These cops came in. Next thing you know, CPS is involved again, and they're taking and they're saying, "Oh, now it's child endangerment." I mean, you can have this. You can be falsely accused in one moment on something, and then the very next moment you can beat the shit out of someone, and now you've got an actual situation of abuse. All right. Spoiler alert. That's where we're getting going a little bit there, but not yet. Not yet. So let me see here. I'm gonna pull this aside, and I want to go. Let's go to the omnibus in hearing. Okay. And so let's go. I want to go cam 1. We're not gonna go there though. Let's blank that out. Let's go with the ruling. Why is this ruling not showing? Why? I had this all set up to go, and now it's giving me troubles. Okay, I wonder if that's good there. Oh, I don't know. I don't know why it's not allowing me to come in. Hang on, people. We're gonna get this. We're gonna get this going here at some point. Okay. There we go. Now we're omnibusing. Now we are omnibusing. Let's see if the other one is working too. No, it's not working either. So we're going to have to see about, oh, there we go. So we got them both in place. Okay. So I will look right over here. Omnibusing. This is, okay. So maybe I should back up just a tad, get us everybody in gear here. Minnesota, I don't understand all of it, but they have this omnibus hearing, right? It's like a pre-trial conference type of thing or hearing. And you go in there, you can file your motions to dismiss or whatnot, but it's basically, do we have enough to present the case and to go on to trial? Okay, that's what they do here, and that's what happened. So Nick, for his point, he files a motion to quash and the warrant, but he also requested a Frank's hearing. Okay, now this is your time to get all these initial filings up front and in place. I don't know, to dismiss or he didn't do that though. So, there you go. So he files this in the Franks. Franks is Franks v. Delaware. It's this case. Basically, I don't remember what year. I want to say 96. I could be wrong about that. But the whole tenet here is that to review a warrant, if something was presented in application for the warrant that was material, but not misrepresentation, they said, or leaving out, but a material misrepresentation or a lie. It has to be something into the egregious point like that. But for that little fact, the warrant would not have been issued. Okay, that's what Nick said. Now, remember that. Someone just put something here that I'm interested in seeing. Remember that. I don't remember what I was saying now. I got distracted here. Let's go with this. Grace Sprocket said child endangerment presumptive with the drugs and illegal firearms because of the drugs. Child endangerment actual from the 10-time threshold Coke and the 8-year-old here. Yeah. But, Nick's point that we were just going over there was that it never should have got here because of the CPS letter said everything you're doing is legal from a social works point of view. But see, that doesn't make sense because the Pomplin did not request to do anything other than to search the house for cocaine, which is illegal. Okay, that's illegal substance. With that in mind, do I think it should be? That's not the question. We're talking about the statutes and how to think that way. With that in mind, Nick says he was doing that. I can't even mock this anymore. It's so stupid. All right, so here we go. Candy High. Remember. I don't remember the something of November. Nick. Okay, so the Frank's motion, he had filed that. The state came back. We've gone over all that. Now here is the judge's ruling. And spoiler alert, it was denied. But we're going to walk through the reasons. I will skip some of the stuff, but I think it's very important here because the judge breaks this down in pretty good sense. So the above entitled matter came before the Honorable Stephen J. Wenzel, Judge of District Court on August 21, 2024 for omnibus hearing at the Kandiyohi County Courthouse, Wilmar, Minnesota. Defendant Nicholas Robert Rekieta appeared and was represented by Francis White, attorney at law. The state of Minnesota appeared and through Kristen Pierce and Jordan Engler, assistant Kandiyohi County attorneys. Defendant is charged with 3 counts. Okay, second-degree controlled substance possession. I believe he can still be charged additionally if there's anything else that they want to bring up, but I don't know if there's anything else they should. Second-degree controlled substance possession, a felony, a violation of Minnesota statute, possession of a firearm, pistol, semi-automatic military-style assault weapon, ammunition by an ineligible person, a gross misdemeanor in violation of Minnesota statute, and child endangerment, exposure to controlled substances, a gross misdemeanor in violation of Minnesota statute. All of that was charged, and CPS did get involved because all of that is illegal activity. Okay. Sorry, Nick. Defendant seeks a Franks hearing and contests seizure of firearms. At the hearing, the defendant offered, and the court received without objection, Exhibit 1, application for search warrant. Exhibit 2, Rekieta redaction.pptx. Rekieta video, okay? Exhibit 3, supplemental report 1. Exhibit 4, Rekieta.png. And Exhibit 5, letter from KCHHS, the actual letter. So the judge is going to be able to determine here if the activity that was taking place was legal or illegal activity, okay? The defendant offered and the state objected to Exhibit 6, recording of Steel Toe Morning Show from May 22, 2024. The court took admissibility of Exhibit 6 under advisement. After review, the court determines Exhibit 6 is admissible. It could be entered. And as offer of proof, the state uploaded Exhibit 10, Nick Rekieta's stream, on August. Remember, so this is Nick filing this, and I told you that last time, which is, he's put in the entire video. Now, they did a screenshot, which was just the record player of him before he went and take a piss, I guess, and do some blow. But the judge apparently is going to review everything. Right. I don't know what just happened with that camera, but we'll see. Maybe we're just this camera. And after review, the court determines Exhibit 6 is admissible as an offer of proof. The state uploaded Exhibit 10, Nick Rekieta's stream, on August 30, 2024, after technical difficulties with previous MDNES video uploads. Supplemental report 8 uploaded on MDES and referred to it in defendant's reply memorandum was not offered nor received at the hearing. I don't know what that one was. Following a briefing schedule, the court took the matter under advisement on September 6, 2024. 2024, based upon the files, exhibits, records, proceedings, and being fully advised in the premise, the court makes the following findings of fact. So these are now factual issues upon the court. Yeah. So Grace, look, they found cocaine in the 8-year-old. Technically, yes. I don't know. Kids grow up really fast. Yes, we talked about that. The hair follicle test, which I just had a client do one this last week. They're pretty reliable. I don't know what happened there. I know Nick got his kids back. I don't know if they retested this child, if that was actually a false positive. I don't know, but that was a very big problem, and that does not seem to me to be what you would call legal activity. Okay, just throwing that out there. Okay, May 22, 2024, Quinn Pomplin of Candiaho County Sheriff's Office submitted an application for a search warrant supporting affidavit and search warrant regarding the premises, gives the address, Minnesota and Nicholas Rekieta defendant. The address subject to the search warrant was known by Deputy Pomplin as the defendant's residence. Okay, I'm gonna hold this here. This is one thing I did not do, but I'm going to do it right now, which is remember, I don't know why I say remember, is he a detective or is he a deputy? Okay, because now the court's calling him deputy. Okay, and let's see, I have Nick Docs. Let's see here. That's the motion to dismiss. That's not the one I want. Let's go back here. Nick's response, denial on the Franks. No. How about, I think I know where it is. I think we talked about it last week. Legal stuff. Rekieta docs. There we go. Wow. I don't know if these are, let's see if this is the one. State of Minnesota, state's memorandum. No. Now I'm not gonna. I need to know this though. Search warrant. There we go. Search warrant. Application for a search warrant. Quinn Pomplin. I'm licensed. I make application to this court and the warrant. I know. Maybe we got to go down to the end to see where he signs it. Where are you? Quinn Pomplin, County Cohai County Sheriff. I declare. It doesn't say. It doesn't say what are you, Quinn Pomplin? Are you an investigator? Are you a detective? I don't know. So, there it is. Receipt, inventory, Detective Quinn Pomplin. So it is detective. At least that's how he signed it. So he is a detective, folks. And with that in mind, we are going back to this. So if the judge is calling him, maybe this is where Nick's going to appeal, right? He's going to appeal this because he should be calling him detective. And now even the judge is getting this wrong and calling him Deputy Pomplin. The search warrant was for controlled substances prohibited by law. Let's go back. Prohibited by law. Oops, that's not the one. I took down the slideshow now. Okay. I'm still getting this shit figured out here. So let's go back here. There's the slideshow, right? So there it is right there. You're missing it. Even if true, he has to investigate legal activity. CPS would not amount to criminal activity. Okay. I don't know if I believe that, Nick. Don't know that I believe that part. Okay, let's go back to, I know, we're getting all confused here. The search warrant application states May 16, Officer Sergeant Dave, is he an officer sergeant now? No, we don't even know. Nestor received a report of possible child neglect and controlled substances involving defendant and his minor children. Deputy you guys tell me, is deputy or detective, which one's higher? Did he get a promotion or demotion since then? Maybe that's what happened. Pomplin reviewed defendant's social media videos. Deputy Pomplin notes that defendant's appearance in the videos changed. So he talks about the change. Deputy Pomplin reviewed Aaron Himmelt's social media. Aaron hosts his own media program. From watching Imolti's videos, it is apparent that defendant and Imolti previously had a relationship. And having since had a falling out, Imolti states in his video that he recently experimented with cocaine and Molly. gives her the proper Molly too. Why is cocaine not capitalized and Molly is? On May 22, Immolti uploaded a video where he spoke about defendant and insinuated defendant was using controlled substances. During Immolti's 2022 video, he referenced the video posted by defendant on May 21. Immolti notes that white powdery substance can be seen. So yeah, Aaron says it can be seen. We've all seen it out there, okay? Defendant May 2021 video was removed from the internet. Defendant Deputy Pomplin was able to review defendant's May 2024 video. Defendant May 2020, the 21 video is 4 hours and 4 minutes and 4 seconds long. You've skipped the 4 seconds there. At approximately 2:46, defendant leaves the video to use the restroom. Upon his return, approximately 2:50, defendant appears white powdery substance. Defendant's demeanor is excited. He points slurred speech. Deputy Pomplin was previously drugged. Yep, we know that. Deputy Pomplin summarizes Immolti's video. There's no indication that law enforcement viewed an altered or edited version of defendant. So yeah, they posted that backwards, whatever guy, Cog's Life or whatever on there. And so the judge is able to review that. Whoops. Even if it was not the original posted video. Yeah, because that's what we've always said. May 23, 2024, law enforcement officers executed the search warrant at defendant's residence. While at the residence, they found black vial and with white substance inside the master bedroom near nightstand. Both items field tested positive for presence of cocaine. Yellow snort tube, positive for cocaine. 22 caliber spent shell casings, positive for, oh no, near the nightstand. Remember, that was part of his his artwork, right? It was only up there, the artwork, because 22 Sig Sauer AR with several mags and loose ammo under the bed, the master bed. Under the bed, loose ammo and a gun under the bed. Once again, plain view. Robert Barnes, vaunted expert on legal stuff. He's always right. I needed laughter. Here we go. Right, he's wrong. Glass container with metal filter and grinder. So they found April under the master bed too, and tested positive for presence of cocaine. 45. By the way, a solid joke. Grinder. 45 caliber bullet in master bedroom closet. Okay. Bag with cards and dollar bills. Field tested positive for cocaine. Corner cap baggie, white powder, master bedroom, field tested positive for cocaine. I mean, we can keep going, and I'm going to. 3 small baggies. In case Nick chimes in here, he can tell us what actually was in there. Field tested positive for cocaine. Green colored tablets, ketamine, digital scale, positive for cocaine. Metal pan, white powder, master bedroom, safe, cocaine positive. 2 snort tubes, 2 metal cutters in a master bedroom, safe. And by the way, this is the problem. This is the problem with you going on stream, looking the way you are, and doing coke in general. If the cops are going to come in there, you got kids, you're prominent, it's way too obvious what's going on. Coke can be found anywhere. So the search warrant, it's not a general search warrant. It's the search warrant for your house to find cocaine, okay? If it was a search warrant in your house to find a motorbike or a giant mixer, you're only going to search places that those things can be, right? Maybe a stolen hot tub, right? But cocaine could be stored, and usually is stored, little places, right? $100 bill, positive for cocaine. Bindle white bag, white powder substance, bedroom closet safe. He's got a lot of safes. Cocaine scooper in master bedroom closet safe. 2 baggies within a baggie and with the funnel master bedroom closet safe. Unknown brown substances. And by the way, it is interesting. This I don't know, which remember the situation, which is they go to Nick's house, they pull Nick over. He doesn't know what's going on. The cop's like, hey, we got a warrant to search your house. And he's like, you don't got to come back when you got a warrant. And like, we have a warrant. Okay. I don't know if you're drunk driving right now, but we've got a warrant. Your daughter's at the house. She's scared. She's not letting us in. Can we have the code? And Nick goes, no, you can't have the fucking code. Get a warrant. And like, well, we have a warrant. Now we're going to break down the house. You want that? And then Nick's evidently, yeah. So they bust down the front door, which can be pretty traumatic for the kids. Okay. I've said that a few times, right? It's not the way you want to do this. They go in the house, they're searching. He's got these safes. I don't know. I mean, you'd think that at that point, Nick's like, I'm not going to give you access to my safe. But somehow they got in the safes. So, quick question. Safes probably aren't our statement. I'm presuming safes are not locked. They're just, these are just unkept storage compartments, doors, heavy doors, wide open. That's my assumption. I don't know. Someone tell me if they see it. But you know, there you go. Okay. Oh my God. You got to take a little bit of break here. Cause it looks like, Sean sent us some money. Don't document your crimes. Yeah. Sean, I've been busy as you know, practicing attorney here. So I'm going to reach out to you. We're going to connect and we're going to do some stuff here, but let's keep going. Okay. I appreciate the $2, by the way. And $4. Wow. My watermark. Yeah, that's true. Well, guys, take it from Sean. That's how you do it. You go into the chat and you throw some money aside. Okay. Okay, so let's keep going here. Remington, another one, 45, another Remington, shotgun in the garage, the total measurable weight, and we've talked about this. Sean, everyone else has talked about this, could potentially, because this is with packaging, 26.67 grams. I think 25 is the threshold that we could be pulling back on that, which means, you know, go, by the way, I do implore everyone to go check out Sean's stuff. I've tried, by the way, when I see this and everyone's done the breakdown, I've not been watching them because I want to not be tainted. I don't want to say, and here's the most important part. Tyler, do you want to step on the toes or do you want to have your own legal stuff out there? No. The legal stuff, it's the jokes. The jokes, I want my jokes to be my jokes. By the way, they said they found Grinder. And I'm like, so they're talking about Aaron, right? Or April, I'm sorry. The jokes are more important than the legal analysis at some point, okay? The crossover. So if you want to get the real legal analysis, go to Sean, go to Legal Mindset, Andrew, Kurt, and all those guys. They're doing a great job on this. Just throwing that out there. The information contained in the search warrant was accurate, reliable for the reviewing judge. There's no clear false statements, significant material omissions, or material misrepresentations that caused the search warrant to be false, misleading, or in violation of the defendant's constitutional rights. All facts contained in the memorandum of court are incorporated by reference as findings of fact, part of the record. The important part here is what we had said with, remember, let's see if we go back here. I'm going to keep showing this. Damn it. It's still working on this stuff. Working on, there we go. Now we'll be able to do it. Slideshow. There we go. That's Nick's thing about illegal activity, illegal stuff. Sorry, we get to say, nope, that's not the case. They found stuff and it was illegal stuff. Okay, Nick? All right. I don't know what I really wanted to say about that. Okay, so there you go. Well, here's what I was going to say. The judge has the letter, the CPS letter. The judge was able to read that. Okay. So I think the judge got a little bit of an understanding. Was this even important? I've pointed out, and I will keep doing that. My analysis from what I've seen here is the letter was issued the same day that Pomplin began his investigation. Okay. One ended, he began. And at that point, you know, things change. More things come to light, like diddling yourself on screen. Okay, here's the order. The defendant's motion to schedule an evidentiary hearing pursuant to a Frank's challenge is denied. The defendant's motion to suppress the firearms ammunition is denied. All other omnibus issues not argued with particularity or otherwise specifically identified to the court as a contested issue at the omnibus hearing, whether included in the written notice or not, are denied, having been waived by the defendant. So, once again, I don't practice criminal law. I don't know specifically what else he could have, what you can't do pre-trial that he's basically barred from bringing now, you know, a motion to dismiss, I don't know, body cam footage, you know, a bunch of other things. He's going to do them, you know, motions in limine right before trial, obviously. But I don't know. It sounds like that to me could be a big problem. Once again, if I practice criminal law, I'd probably know the details of projecting out what you should have been filing at this moment to make sure. Now, once again, he must have known something because remember, he did part of his first initial filing here was an issue about April's testimony, you know, that was basically, they had Mirandized her, then she's been talking, hey, don't talk, And they're saying, oh yeah, we're not going to do that unless she's going to testify. So there you go. Boom, boom, boom. All right. Defendant appeared at the omnibus, charged with 3 counts. This is the memorandum of law. They're going to break this down here. Defendant challenges the validity of the search warrant and moves for a Frank's hearing. Defendant also challenges seizure of the firearms during the search warrant's execution. Warrant challenges. Defendant argues Deputy Pomplin made false statements or recklessly disregarded the truth of the search warrant affidavit. Defendant points to the following in support of his contention. KCHHS determined a report of possible child abuse did not fit the definition of child abuse or neglect. Nick actually said, they said even what he was doing was not illegal. Remember, that's what he said. Imulte and defendant no longer had an amicable relationship, and defendant alleges Deputy Pomplin. I just went over this. He's a detective. Watch defendant's video YouTube on third party's YouTube channel. U.S. and Minnesota constituents guarantee the right of the people to be free from unreasonable searches and seizures, and provide that there must be a finding of probable cause in order to issue a warrant. U.S. Constitution, 4th Amendment, Minnesota Article 1, Section 10, probable cause to issue a warrant exists if an affidavit sets forth competent evidence sufficient to lend a reasonably prudent person to believe that there is a basis for the search. State v. Con, a search warrant is void, and the fruits of the search must be excluded if the application includes intentional. This is the problem. Intentional or reckless misrepresentations of fact or findings of probable cause. The whole, my watermark and some of those were not intentional misrepresentations. If anything, it was, I said at the time, remember I came out last week and I was freaking, hey, here's what the detective actually said. It was removed. It was taken from. He didn't say it was removed. He said it was taken from the internet. And so it's like, okay, does that mean it was taken or taken down? Or I think he said taken down. So the way it did, you're not really sure which way. What does he mean? Does he mean it was removed? Does he mean that he downloaded it from there? And he could have been a little bit more precise, right? But that's not what this is about. It's not like a warrant's going to be but for precision in the way we write, okay? The two-pronged test under Franks requires the defendant to first show that the affiant deliberately made statements that were false or reckless in disregard of the truth. We haven't seen statements that were deliberate. He watched the video. He saw what he saw. He saw what everyone saw. There you go. This was, and the problem for me is, I should have said this at the start, which is I don't begrudge Nick at all for filing motions, trying to get his ass out of jail, to get back to his kids or whatnot. You do everything. That's what we do. That's why you get an attorney. That's why we have trials. That's why we have attorneys to help you at trials. Sorry, Daryl Brooks, I know. But it doesn't mean that you then go, and this is the problem. He's gaslighting us all with his message. He's gaslighting us all by mocking everybody as an attorney for having a difference of opinion. And I've talked about this over and over. Hasness, the myth of the rule of law, which is you understand that arguing from either side, there's two sides of this coin in a sense. I see that even more than most when I have a client and, in your family court, you have on one side of the issue one time and you're on the other side of the issue another time, okay? And it doesn't mean that it's only one way that it goes. It means that one, you can easily help your client understand the pitfalls and how to get through this kind of stuff, unlike a Barnes, where I don't know that he understands both sides of it, so he's only the Nick side of it, right? To warrant an evidentiary hearing to challenge the validity of a search warrant, the defendant must make allegations of deliberate falsehood and reckless disregard for the truth, accompanied by an offer of proof. The offer of proof should point out specifically the portion of the warrant affidavit that is claimed to be false and should be accompanied by a statement of supporting reasons. No Frank's hearing is necessary if there is an absence of evidence that an officer deliberately or recklessly omitted or falsified information material to the probable cause determination. I'm not going to read all the case names here. You guys can check that out. In reviewing the offer of proof by the accused, if the district court finds mischaracterizations, the accused may not necessarily be entitled to a hearing. If the mischaracterization was the result of negligence rather than deliberate or reckless disregard for the truth. So negligence standard doesn't work. It's all about, basically think about it like defamation, malice in a sense, really what you're looking at here. I'm going to get this warrant and I'm going to be untruthful about what we're stating here to get it. Defendant first concedes Detective Pomplin did not state in search warrant affidavit that, I'm just going to call it CPS, determined on May 20 that a report of possible child maltreatment involving defendant's children were found by KCHHS CPS to not meet the definition of child abuse. The information provided in the search warrant case background indicates Sergeant Dave Nestor received a report regarding possible child neglect and controlled substance use. I don't know what to say about that, Nick. I don't know what to say about that because it depends what substance you are talking about. Perhaps at the time, the family or whoever reported that to KCHHS did not think, maybe they said alcohol. Maybe it was alcohol. You're drinking too much on stream. I don't know what the letter is in there, but you're claiming to me, if I take you at face value, it's kind of tough, that what was reported was not illegal activity, okay? That's what you're saying. So in other words, what you're telling me is the report that was made to CPS in this letter and that they said was not, if I'm taking you honestly, it was not coke. Substance use could be all kinds. It could be prescription, alcohol, weed. Is weed legal in Minnesota? I don't know. Baldos? I mean, is that what it is? The statement was used to provide background information to explain the origin of the investigation involving defendant. There is no mention in the affidavit about any investigation by a CPS. A CPS determination and investigation is largely separate and held to a different legal standard than that of law enforcement. The crux of the warrant was not the allegation of child maltreatment. It simply provided context for the law enforcement to begin their investigation. That's what, yeah. The statements or lack thereof regarding CPS investigation is immaterial to the search warrant and therefore does not amount to deliberate falsehood, nor does it make the reckless disregard for the truth. Damn. Water, by the way. It's not alcohol tonight. Defendant next argues that Deputy Pomplin misrepresented the relationships between defendant and Aaron. The affidavit states throughout Imolt's, the video blogs, it is apparent that they and the Rekietas were friends and have recently had a falling out. Defendant asserts that Imolt and I'm going to say Aaron and defendant's relationship had deteriorated beyond a mere falling out, and that by failing to include disparaging statements made by Aaron on his videos about defendant, Deputy Pomplin made a material misrep of the affidavit. The affidavit further explains that Aaron posted a video on May 22 where he speaks about defendant and insinuated controlled substance used by defendant. However, Deputy Pomplin also included information that Aaron admitted to recent controlled substance use, which is essential information for a reviewing judge to determine veracity. The case background proves sufficient information to provide context of the relationship between defendant and Aaron. Excuse me. Sorry. And provides information. The information provided by Deputy Pomplin about defendant and Aaron does not amount to misrep presentation. It accurately describes a relationship and includes information necessary to determine veracity of any statements. Importantly, the information with Aaron's videos is not the sole basis of the search warrant, and certain statements of defendant's drug use were corroborated by defendant Pomplin's own observation of defendant's video and a powder on his nose consistent with legal controlled substance and behavior consistent with being under the influence. Defendant's claim is that Pomplin did not view defendant's original May 21 video from defendant's YouTube channel, but rather watched the video from a third-party channel that reposted defendant's video and did not watch the video in its entirety. Here we go, folks. This is the part we're going to determine whether the judge believes my watermark or if it was materially altered. And then this is basically a misstatement and a lie. The search warrant, which we already know it's denied. So sorry. The search warrant affidavit states, quote, your affiant was able to review that video that was taken off. See, that's the part. It was taken off of defendant's YouTube and Rumble media sites. The video is from 5/21/2024. Pomplin notes that defendant appears to be drinking an alcoholic beverage, and later in the video appears to have white powder on his nose and behavior indicative of controlled substance use. The case background states the entire video is 4 hours, 4 minutes long. I think it was in 4 seconds. And approximately 2:46 into the video, defendant leaves to use the restroom. When he returns, 2:50:40, he appears to be making an excited look and has white powdery substance on his nose. Deputy Pomplin also notes that during the YouTube video, defendant has to, quote, close one eye to read the screen, rambles, slurs his speech. We've all been there, right? These above timestamps described by Pomplin are consistent with defendant's 2021 video uploaded by the state. Based upon the court's review of the video, Deputy Pomplin, and yeah, so every one of us were doing this, right? We were watching the original, which is still up on Odyssey, and then we were taking the Cog's Life one, and we were going timestamps, and they match. So it was a sad sight. Based on Deputy Pomplin's description or accurate representation and defendant, it is unclear if Deputy Pomplin viewed the video from defendant's YouTube channel or from a third-party channel. Yeah. The state noted that the full video from defendant's YouTube channel was disclosed to defendants on July 3, 2024. Even if the video of defendant was a copy taken from a third-party posting, there is no suggestion that the content itself was doctored, clipped, altered, or otherwise changed. Yeah, the judge was able to pretty much make this determination himself. Defendant also argues Pomplin did not watch the entire May 21 video and only watched a 1-minute clip contained in a PowerPoint. The PowerPoint clip contained an exhibit shows the defendant's video is 4 hours. Now they get the 4 seconds in there too. When that image is cross-referenced to the full video of Exhibit 10, the same image appears at the corresponding timestamp. Exhibit 4 is the image that was taken from the clip of the PowerPoint file. When the image of, this is embarrassing, Nick. It's cross-referenced with the full video of Exhibit 10. The same image appears at the corresponding timestamp. There's no evidence that the images of Exhibit 2 and 4 are inaccurate depiction of defendant's May 21 video. Most notably, Deputy Pomplin asserts in the affidavit that he watched the entirety of the video that was disclosed to defendant and provided to the court. Wow, that poor guy. He'd been drugged through the mud, but he had to watch that whole thing too. The court does acknowledge that it gives a reprise about social media, but this is not a parody or otherwise inaccurate parody. There is insufficient evidence to show that Deputy Pomplin made statements or omissions in the search warrant affidavit that were false or reckless disregard of the truth and material to the probable cause determination. Therefore, a Frank's hearing is not required. Seizure of the firearms. I mean, we're going to go through this quick because this is just too obvious for me. The warrant. Why is this thing shaking here? The warrant may be issued to search a particular place, probable cause, Search warrant may not exceed the scope of the warrant. The test for determining whether a search has exceeded the scope is one of reasonableness. And they give a lot of case law stuff. And then you're going to say plain view. The plain view exception here, search warrant provided the police were entitled to search the premises and defendant for controlled substances, including meth, coke, any other controlled substances prohibited by law, and paraphernalia commonly associated with sales and use of controlled substances. Items that would show controlled substance use that would not qualify legal drug paraphernalia. Law enforcement officers had a valid search warrant to search for those kinds described in the warrant. Therefore, under the general rule regarding the permissible scope of valid premises search warrants, officers were authorized to search all areas inside defendant's residence where one would reasonably expect, under the bed, they found it, including containers that can contain concealed such items. During the course of searching for the items named in the warrant, firearms, ammunition were discovered in the areas where drugs could be kept during the search. The evidence of controlled substance use was also found during the execution of the search warrant, namely controlled substances, field tested positive for control. Yeah, and they're not dumb. They know that you can't have guns when you have a coke. Defendant made a vague passing reference to a probable cause challenge on page 8 of defendant's reply memorandum filed September 6, 24. this probable cause challenge is untimely and not properly noticed or raised at the hearing. Oh, say what? There you go. Okay, so with that in mind, what are your feelings? And then we'll walk through some of these chats here. What are your feelings, folks, about this? What are your feelings about the results here, right? Which is, I mean, it's hard not to, and by the way, this is because I'm not a fan of like I said, over prosecution or, drugs, guns. I'm fine with all those things, right? But you got kids involved here. And then the reality is we've got the law. And I think I would have more sympathy for Nick if he had come out right away and just shut the fuck up. Okay. Not said anything. He's not online. He's just dealing with it. And we don't know what's going on. But when he's gaslighting us all the time, then I'm just like, I don't know about a gloating thing, but I mean, it's like, you were so wrong. And you know what it is? It's more the Barnes and Viva Fry. Those two guys are just disturbing as all get out. So it's at some point you're just kind of sitting here going, okay, I don't know what to say about this. Okay, it's a lot of chats here. When searching for a tiny bag of drugs, everywhere is yes, exactly. This isn't how it works on the gram and talk counselor. This isn't how it works on the gram and the talk counselor. I don't know what that is, as the kids say. Yeah, say hi to Sean in the chat. Sean says, not going to lie, this is the typical amongst my clients. They'll focus on something irrelevant, like the CPS letter, and build a mountain out of a pile of sand. That is so true. And by the way, so you can imagine what it is. This is where being a good attorney, hopefully, I think I am, really comes into play, which is when you're going to present something to the court, especially family law is lot different. Okay. There are times where you're doing memorandums of points of authority, a lot like this, where it's a technical issue. I've talked about this before, where you've got a good mix between law of equity and just the rule of law, where you're, here's a statute, here's it breaks down, and then there's what's fair. And family law is a mixture of those two. So at some point you're trying to be persuasive and you're trying to massage what you have here. And then a lot of it, you go into court, doing a lot of these little hearings, 10, 15 minutes before the judge, and you've done a filing, and did you read it? Well, did you get it in front of the judge in time? Now, is it, multiple pages where the judge is just going to gloss over? Because you can tell that. So try to be short, concise, and what's most relevant. And if we have to, we'll put some more other stuff in there. So yeah, completely. Challenging probable cause, challenging things into Bruin, general suppression. His attorney pissed it all away. Okay, so that's what good point, because Bruin would have been an interesting aspect to this, but I don't know that, even with the new ways that they've been ruling on Bruin with Rahimi and such, I don't really know that there's much to go on there. There will still be motions in limine if this goes as far as trial. Yes, I agree. Nick hired the attorney. He just, yeah, okay. Maybe Nick is still using and directing the case game plan would be my guess. Yeah, that's probably, here we go. Scott says, Nick, legal bricks Rekieta. A lot of mocking of Nick in here. But Barnes smokes big as far as he has to be smart. Okay. I'm with you, Dwayne. That is a good point. Using a Baldo near a minor is certainly a crime. Discussing Baldo use near a minor is likely a crime as well. Nick B. Pomplin, that white powder. Okay. Nick has to hate the fact that a couple 100 years of court cases go against him. Yeah. And look, I will take this, and I'm still planning someday to do this, which is a breakdown of the 14th. And look at this. Here's a book by Raulberger, okay? Government by Judiciary, okay? This is a pretty thick damn book. It's all about, and it doesn't look like it's carved up much, but I've been doing my best. It's all about the 14th Amendment, okay? And I believe the 14th Amendment is totally, one, it was bad, that it never should have passed. And then when the way it's been applied, incorporating all the Bill of Rights to the states, is not how it was intended at all. But that's the way the court's ruling. That's the way they go. However, with that in mind, you can see this, with Dobbs as an example, you're kind of chipping away at unenumerated rights and we're going to we're going to go into a new section here, which is about rights. But unenumerated rights and what the states can do, and they should be able to make the determination on almost all these things. So maybe someday we'll get to the point where I think we should, which is let's just eliminate the 14th Amendment altogether. But if we don't do that, maybe we strip back incorporation. Now, that's my theoretical little thing we have going on here. But that's not where we're at. So I'm not going to sit back here and pontificate to a client about how things shouldn't be and whatnot. That doesn't do them any good, and it doesn't do Barnes any good to be telling Nick this kind of stuff, or to be telling all you guys, because what you do then, and by the way, I do have to make a correction, right? Last week I had gone off here on Barnes because that's easy to do, and I had made a mention that he was, let's see here. I think I got one specifically for this. There we go. No, that's not the right one either. It doesn't matter. Let's see here, other rulings. Now it's not going to show up. Basically, Alex Jones has done a motion to set aside his verdict, but only in the case up there in, what is it, at Massachusetts, or where is it at here? Waterbury, I don't know, Superior Court complex litigation. Waterbury, where's Waterbury? I don't know, but he has done that, so he's got a little bit going for him on that side. But he didn't do it in Texas, so I don't know where that all stands. Other than we'll still work on it. I just wanted to make my correction there, right? That he has done something there. Okay, let's go to the next thing, which is, and we'll just do it up here real quick. I do have a case I wanted to get to. Hopefully it'll be done with the Nick stuff, and then we can move on, and I could talk about. I want to talk about this family law case, okay? And it came out, and it's dad and mom. They're having a divorce. She's a doctor. She goes completely nuts. Her and her sister, they join a cult. And then it's a ruling about can the aunt be around the child, and can the court order that is that she can't be around the child. Evidently they can, right? So do your First Amendment rights extend? Right to association. For your kids, can the courts do that kind of stuff? Well, they do it under the best interest of the child, and they do it quite often, all the time. But I will get to that one. Maybe I'll get to that one next time, because I do want to talk to, real quick, we'll play a few little things here. Here we go. Okay, so maybe, let's see, one, damn it. This is problematic. Oh, there we go. There we go. So this is Tim Pool. He had this guy, Andrew Wilson, on. And wait, Lincoln says people listen to music while they work out. I listen to my guy Tyler. I thank you for that. Barnes is chilly without a camera. I don't know what that means. Oh my God, hi Lincoln. Okay, so Andrew Wilson, remember I've got to snip that one in the bud. Remember, he had gone on Dave Smith's show, and they somehow got into family court stuff. And it was all kinds of wrong. Okay, it was wrong from Dave. It was wrong from Andrew. But Andrew's friends with this attorney, so he knows and he was wrong. I don't know if the attorney's telling him wrong or he's misunderstanding. However, he came on to Tim Pool's show here, and they had a little discussion. Now, I actually think Andrew is a little more right than Tim Pool. We're going to play a little clip here, and then I think we're going to play one last clip of some other ones, because I think here's the deal. You've got to know where your rights come from, okay? Some people, Andrew says, it's all about force and your ability to exude force on someone else. Tim Pool has a weird, convoluted way. I think I go about it the Hans Hermann Hoppe way, which is argumentation ethics, and I'm still getting to understand all that. But to me, rights are all about property rights. You own yourself, and once you own yourself, you're able to, own property. But self-ownership is part of this, right? Anyway, let's go here and play this little.
Hang on, let me finish. If you have a right to a stick, sharpen it, pointy stick, you can defend yourself. I'm going to stop you.
I'm sorry.
Government enshrined protections are not real.
There you go.
Rights that as we know them, are just things that we recognize as things of value to us. So for instance, I usually define it as simply, you have a right to speak freely. If you're in the middle of the woods and you're buck naked, you can say whatever you want. You have a right to keep and bear arms. Pick up a stick, sharpen it, pointy stick, you can defend yourself. Ain't no one going to stop you. The question is, when you get into conflict with someone else, where is that line drawn? So the reality is, rights are recognized as things that we can and must do to survive and maximize.
I think rights are force, and I think that
You think rights are force?
Government
rights are
protection.
What do you mean rights are
You're
force?
talking about government protection.
No, I'm talking about period.
So look, he's going to explain it a little bit more. One, Tim Pool is just all over the place. It's what you need to survive. Well, okay, then he's going to mock later on some other stuff that don't make sense. But Andrew, you got to have it more than just it's force. Okay, you got to have it's a complex issue, and I think people they intuitively think what rights are, and then some people say it's more, and some people say it's less. But there's an intuitive understanding. But we've got it. If you have to explain that, or you have to really, maybe have a conversation with someone. Let's say you believe they're God-given rights, natural law. Well, what if you're not religious? How are you going to have a conversation with that person? Okay, but anyway, let's keep.
I'll explain what I mean. A right to me is an entitlement absent duty. That's a right. Okay, you're entitled to it, but you have no duty.
What does that mean?
It means that you have it. So like, okay,
entitlement to speak.
Yeah. So if you have a
I will say this: that's a pretty simple explanation. You're entitled, but not a duty.
right to own a gun,
to speak.
No, hang on. Let me finish. If you have a right to own a gun, do you have a duty to own a gun?
What do you have a duty to speak?
No, you don't have a duty to speak.
If you have a right to vote, do you have a duty to vote?
So it'd be an entitlement.
That's your argument.
It's an entitlement,
but
absent a duty.
But you can speak.
Yeah, you can.
And so
until you can't,
the question,
until somebody stops you with force.
So you're talking about government restrictions are made up by us as a people.
Just people can adhere to your rights without any form of government. If you're walking down the street and you speak, and a guy turns around and smacks you in the mouth and breaks your jaw, right? He has now used force against whatever this right you think you have to speak. You have no right to do shit except whatever you can enforce. Right. Your mechanism is force, and the mechanism against you is force. And so all rights are force.
You're talking about government protections, not rights.
No, I'm talking about rights. What is a right?
So it is an intrinsic moral function.
Well, okay. Or intrinsic meaning what?
It means, again, I'll try to explain. If you're born and you live in the middle of the woods, there are things you can do. You can hunt for food, you can defend yourself, you can speak freely. Now, what we've done in the United States
Unless you're born blind and you can't talk, right? Then where does your right to speak come from?
Okay, by the way, I don't want to nitpick here, but speech has been determined to be more than just the vocalizing, right? It could be burning a flag, okay? Actions can be determined as part of speech. So this really is, and I don't want to mock Andrew because I think he's a smart guy. I don't agree with a lot of what he says here. I just don't think this has been a well-formulated argument for him, and so it goes down a place where one argues this way and one's over here arguing completely something else, and it's ugly.
You lack the ability to speak, right? But you still have the means by which you are allowed to do it.
Yeah, but what makes it an intrinsic right to be able to do? Like, where does this idea come from, other than you axiomatically kind of just say? You say because I can do something, I have the right to do something.
It's part of a evolutionary biological structure that resulted in the survival of humanity.
So if I grab a spear and I can stab somebody with it, I have a right to.
No, that's attacking somebody. That's violating.
Yeah, but other than an axiom of you shouldn't do that because I just don't feel like you should, what makes it intrinsic that I don't do that?
That you don't go and kill another person?
Yeah. So
the way I view rights would be things that and again, there's a debate over what rights are.
Yeah, let's start with that. What are they?
No. So there, it's honestly difficult to define, but it is certain moral structures or.
I would say axioms. Would you agree with that? Just an axiom. So like, you have inalienable rights from God according to the Constitution. This is an axiomatic principle. It means this is our like philosophical starting point. Is that we have these.
I would put it as things that were required or greatly beneficial to the survival of an individual that we greatly benefit.
Yeah, I agree. We benefit. I just don't know what makes them intrinsic, or like you're born with them, or something like this. Other than we just kind of agree to it.
So I think the restrictions we kind of agree to, and some people might view some things as rights and other things not as rights. Mm-hmm. Like the left thinks healthcare is a human right, which makes literally no sense.
No sense.
But in terms of your ability to speak, you can walk around, you can speak, to defend yourself, you can pick up a stick, you can defend yourself.
But this goes back to the same argument. I can grab a spear and murder somebody. I can do that. Why don't I have a right to do that?
Because you are now causing harm to another person, which is a detriment.
But why is that valuable?
Why are other people valuable?
Yeah, well, why would that be an intrinsic value? So like,
one would result in the end of humanity, and one results in the expansion of humanity.
Well, no, both can result in the expansion of humanity.
Right, but absolutely not. You're completely wrong.
No, I'm completely right.
You are wrong. Self-defense can result in expansion of humanity if you're using destruction for the purpose of ending something that is destructive. Mm-hmm. But if you are wantonly going around murdering people, you're actively reducing and harming humanity.
Well, okay, but that doesn't mean that you couldn't expand humanity by harming people. There's
so the argument of self-defense is there are things that we believe we must be able to do for the betterment and survival of humanity.
Yeah, but when I'm asking you this question, right, I'm asking the foundation from which you say, I have the right to to speak or write.
We need to be able to in
like
order to
this.
survive.
You because you need to do something.
So
I'm not sure how that means you have a right to it, though.
Okay, that's almost painful at this point. I don't know. Let's see here. Tim Pool's beanie is on too tight. Yeah. Death said, "Who is that troll woman on this?" Right. I don't remember her name, but sometimes she's okay, but most of the time she just says complete yeah, that doesn't make any sense. Complete nonsense. Human rights include the right to life, liberty, freedom from slavery, torture, freedom of opinion, expression, the right to work and education, and many more. I don't know if I agree with that. Perhaps include but not limited to. Okay, but man, I don't know if that's true. I live where free at the point of access healthcare exists. It's very nice. I never have to fear bankruptcy because of a diagnosis. Okay. It is very painful listed. Yes, I agree. So what I would just break down here, there's some people that kind of push back on this. I don't know if you are at all interested in hearing this one. These guys are more along the Andrew side, but I will just throw this in here. Let's see. Is this the one? Yeah, there we go. CJ Engel. I didn't agree with them, but they have some, they're kind of on the, they're a little bit more, they express it a little bit better. Let's just see this.
Into it. So we can end up talking about this is, where do you specifically see rights coming from, and how do you recommend we go forward in using it?
Yeah, I think history is the most powerful argument that we have. I think that when you conceive of rights, like, I'm a Christian, and people want to source rights in something beyond the bureaucratic state, and I do too. I conceive of rights as coming from God, as mediated through history. So that makes me a historicist. Rights are something that are discovered and defined and implemented within the historical process. So you can claim they come from God. Other people don't claim that. They may not have that same ultimate conception that I do. But I do believe in the mediation of history. I do believe in the mediation of our forefathers. I do believe that these rights are inherited. You can talk in terms of transcendent principles that exist beyond just legislation or something like that. But the very fact of the matter is they have to be made concrete by human hands, by the hands of those in power who have the authority to define what rights are.
Okay, I don't agree with that part, because when they can define what rights are, they can define what rights aren't, okay, and take those away. So I don't necessarily agree, and listen to maybe that a little bit more. However, I think I'm going to play this. It's a little bit, it's like 5 minutes here. This is Tom Woods explaining the Hans Hermann Hoppe argumentation ethics, which is, they talked about it a little bit there, and they're going to go here, which is, well, we'll just let Tom Woods talk about it here.
Abundant like air. Supposing we have clean air and its implications. We're living in a world of scarce resources, in the sense that we do not have enough resources for, and resources would include labor power as well, for all of us simultaneously to pursue all the ends we may want to pursue. We are inevitably faced with scarcity. Because resources are scarce, they're not superabundant like air. Supposing we have clean air. Air is so superabundant, we don't argue about it. We don't allocate property rights to air in most cases. Because it's so superabundant, no one argues about it or cares. But most goods do not exist in superabundance. They're scarce. And because scarce resources exist, and because my exercise of a range of control over one thing precludes your simultaneous exercise of a range of control over that thing, the potential for conflict exists by virtue of the existence of scarcity. So if we want to live peacefully in society, given the possibility of conflict that scarcity introduces, we need a peaceful, objective, conflict-avoiding system of property ownership that would assign these scarce resources to some owner who can exercise a range of control over them. So peaceful, well, that's obvious. Again, if we're looking to avoid conflict, we need peace. But also objective. Whatever it is that links me with the good that I exercise control over needs to be something that can be recognized by everyone, that is objective. It can't just be, I've got a feeling that I should own such and such. Well, you might have the feeling that you should own it, and that doesn't avoid conflict at all. So it needs to be an objective link between the person and the object owned in order to avoid conflict. So the system that we're looking for that will reduce conflicts is a system that is going to specify which individuals may exercise enforceable control over which things. Because if you have a right, it doesn't mean anything if you're not allowed to enforce it. I mean, you can talk all day long about your property rights while the government is bulldozing your house. So the ability to enforce the right is important. So this is what rights theory and interpersonal ethics are seeking to address. Now, I think it's also important as a preliminary step to observe that everybody, even thieves, even communists, even fascists, everybody presupposes a theory of rights and ownership. Everybody does. Because the communists are not saying nobody should own anything. They're not saying no one should exercise a range of control over anything. They're saying these people should exercise that range of control, not these exploiters. A thief is saying, I should have control over these goods because I'm big and strong and I've got a gun and I can take them from you, and you shouldn't. So in effect, he also has a theory. It's a crummy theory, but he does believe, he's not saying no one should exercise control over anything. Everybody's got some theory as to who should control property. Bureaucrats, governments, thieves, whatever, free individuals. Everybody's got some understanding of how ownership should be conferred. But what's controversial about Hans Hoppe's argumentation ethics is he's arguing that only the libertarian theory of property can actually be rationally justified. You can have a million theories. This is the only one that can be rationally justified in an argument. Now, how does he come to this very sort of shocking conclusion? And by the way, by libertarian theory of rights and ownership, all he means is the idea, really, that comes from Locke and perhaps purified by Rothbard, the idea that the owner of something is either the first user of the thing, as in the case of a previously unowned good, or the transferee of that good by means of gift or bequest or sale. That's the libertarian theory of rights and property ownership. And he's arguing this is the only one that can be argumentatively justified. Now, according to Hoppe, any type of normative proposition you might want to advance has to be advanced in the course of an argument. We don't come into this world with normative arguments already emblazoned on our brains. We have to hear them. We have to come to understand them, and then using our reason, rationally come to accept them. So we have to engage in the practical activity. We're not disembodied ghosts. We are real human beings who need to learn things in the course of the give and take of discourse and argument. Now, therefore, Hoppe says that given how important argument is to reaching conclusions, particularly to reaching conclusions about how society should be organized and what rights there are and who can do what, well, if there are norms of argumentation that are presupposed by everyone who engages in argument, then it becomes logically impossible to argue against these norms and be consistent. And according to Hoppe, the only property assignment rules that can be consistently advanced in argumentation, such that you are not contradicting yourself, is the libertarian one. So, for instance, you can't argue that argument is impossible because you're contradicting yourself, right? You're making an argument that you can't argue. Or you couldn't try to reason that reason doesn't exist. Well, you're using reason, right, in the very act of trying to do it. So you're contradicting yourself through your actions. So Hoppe, in effect, is going to say that you cannot, in a non-contradictory way, advance any competing theory of ownership titles. So let's examine this in a little bit more detail here.
Okay, I thought we'd be done with that. And I'm sorry, this is our cat. She just joined. Maybe go somewhere else right now. Okay, there we go. So our Nick's rights being, overtaken. I just finished Tom Wood's latest book, Why Your Baby Mama Is Wrong About Child Support. Oh shit! Snap. Tom said he was gonna come on this. That's good, Jay-Z. Is gonna come on this show, but he didn't. He was trying to schedule, and then he was gone, and then next thing you know, he's just ghosted me. So that's what happens. There we go. Okay, so I think that's where we'll leave this one out. Hope you have a good weekend. We did a lot of Baldo stuff, so we're done with that. There was one other thing Nick had. Hang on here. He said omnibus hearing. I think people will be surprised by the outcome because they have really bad legal analysis coming in from Kiwi Farms Law Couch. And Lisa Clips put that up there. Let me just, before we head out completely, and I'm sorry, the music just banged out. This is going to be, if we hear from Nick at all, or Barnes, it's going to be this. This is one of those judges, people. This is one of those judges that is just sucked into the state. They believe it. Maybe so, but this is where we're at, okay? We've broken down these things. We can, the legal part, we've seen that. We've seen the facts. We've been able to break down a lot from the warrant, the affidavit. There's been a lot that's come out there. The coke and the kids, a lot of this stuff, the coke on the nose, we saw the video. This is all out there. So there's going to be blame somehow that this judge, I don't know, maybe this judge is, but it seemed like to me a pretty reasonable and in-depth analysis everything that we pretty much have said. Is Nick screwed at this point? He's screwed. Okay. He's going to have, what's he going to do? He needs to probably plea this situation out. People like Sean, I know there was just a clip up there from Elisa, and I need to probably watch it. But I know you got a bunch of you guys have already said this, that he's not going to be doing any jail time. Quite likely. Okay. Not going to be doing any jail time. I don't know. I haven't read the statutes on that. There's, minimum sentencing laws and everything that goes in there. Perhaps probably best that he doesn't. So that's not likely going to happen. But is he so arrogant as he's been with the, let's go back here with this kind of stuff? Is he still that arrogant that he's not going to take a plea and try to get this shit over? Get back to being a dad with your kids. Your polyamorous relationship. These are the kind of things that everyone's concerned about and interested in. I think his ego and the Barnes people, when he takes kind of that stuff in there, he may push this still. He still may push and go to trial. And then we've got our situation where we're going to be watching this shit, right? We hopefully would be. Question, would rights be defined by the country which one resides in? So rights should not be determined by a government. And we just talked about it here. Tom Woods kind of broke this down, which is you have inalienable rights, right? Rights are all determined from property. Okay. You own yourself, then you can own property and, exchange, sell, da-da-da-da-da. With that in mind, when a government defines where your rights are, then the government can define what your rights aren't, right? They can take those rights away. So that's part of what the Bill of Rights and what we have in the U.S., United States, it is that, your rights are inherent. They come from God. And with that, you have your ability to have property and to defend your property, which is also yourself, self-ownership. That's why guns are important. That's why your speech is important. Freedom of association, being able to do all these things, as he put in there, the libertarian viewpoint of property rights. When the government says you have a right to speak, now they said, the problem you also have with the Bill of Rights is when you start to enumerate these things, there's maybe a justification that these are, something we can mess with, right? It's listed out there. So there's enumerated rights we do have in the U.S. They're listed in the Constitution, for better or for worse. But when the government, these are the restriction. Remember, the Constitution is a restriction on the government. But when the government starts to dictate and different countries start to dictate, it just means that I believe that they're probably infringing on the rights that you have been given. Okay, so there you go. April's discovery papers were filed in her felony case. I did see something about that. But to me, it's just a shotgun. You're going to say everything possible. It'll be interesting to go right. Grace says if he works really hard, he could manage to get GAOL prison, possibly prison. I guess. I haven't really broken that down. Okay, we're done here, folks. Once again, next week, hopefully it'll be a little bit better. We'll be able to do some of these other things a little lighter. I really want to read. There's been a bunch of comments, so posted on the shows after we post them up here. So I need to go through. We'll jump around again. I need to go through the YouTube comments, all the ones that we've been getting, and we will read those out. Maybe we'll have a whole segment for it. So until next time, people, thank you, everybody. See you next week. Goodbye.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you! You started writing your opinions.
And it just makes me wonder, you're dead, bitch. Why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.